but Mr. Fears was Hanna's counsel. When did he become Milwaukee's counsel?
Don't ask me. I am.
I'm just trying to figure it out, John.
I'm just here to rule on things. So I don't care who argues.
Your Honor, I will be making an appearance today.
Calling case A 831-169, Christopher Wren versus AffinityLifestyles.com Inc.
Go ahead and state your appearances.
Yeah, Will Kemp for the plaintiff.
Teddy Parker for plaintiffs as well, yeah.
Morning, Your Honor. Eric Pepperman for plaintiffs.
Morning, Your Honor. Samuel Markovich for the carrier plaintiffs.
Carrier plaintiffs.
Good morning, Your Honor. Joel Odou, Matthew Kaufman, Eric Freeman on behalf of AffinityLifestyles.com and Real Water Inc.
Good morning, Your Honor. Kevin Rising for Costco.
Morning, Your Honor. New Sean Rodini, also for Costco.
Your Honor, Jim Kilroy, Chad Pierce, excuse me, and Don Davis from Milwaukee Instruments.
And Kelly Evans on behalf of Hanna.
Okay, so a couple things up front. We have, I don't know, 122 or so motions to get through in the next 3 days, notwithstanding special settings. We do have a limited amount of time. So today starting at about 11, tomorrow about 11, and Thursday about 10. That gives us about 4.5 hours, 5.5 hours for arguments. So I'm going to limit you. I thought about doing them per motion, but that didn't make as much sense as overall amounts of time. So I'll have comments, obviously. So the 4.5 really is essentially about 4 hours. 4 hours and about 5 hours. So today, plaintiffs get about 2 hours. Defense gets about 2 hours, and that's overall. Same with tomorrow, Thursday, about 2.5 hours per side. That's just, none of us have an unlimited amount of time, unfortunately, so there you go. Doesn't necessarily apply for today, but on motions in limine, while I'm thinking of this, the moving side prepares the order or orders, whether you're prevailing or not, submits them to the other side for review and approval. On all the orders, put the reasons in the orders for the denials or grantings. Supreme Court's been crystal clear. They want district court judges to put reasons in their orders. Let's see. Motions in limine, provisional in nature, granting or denials without prejudice, subject to revision at and during the time of trial. Evidence excluded on rulings in motion in limine, subject to potential opening the door at the time of trial, but to the extent somebody thinks that that door has been open at the time of trial, rather than you unilaterally deciding that that door has been open and putting it in front of the jury, you're ordered to get an order from me before you put in front of the jury any evidence that's been already excluded on a motion in limine. So when you do your orders on motions in limine, put those prelims in there. Any questions about the process? No questions, okay. Oh, I'll tell you on all of these, I'll go ahead and tell you my initial inclinations. I've reviewed an awful lot of stuff. So first up, plaintiff's motion to rehear severance of Cavay case on order shortening time. I'm inclined to deny that for essentially the same reasons I granted the separation of trial previously. Unlike oral argument prior, I don't think there's any 5-year rule issue. I candidly have no idea where that came from, but welcome arguments begin with plaintiff.
Aaron, I just want to focus on two things quickly. The first thing is the court's determination that there was a significant difference in the theory of causation. That's the fundamental determination that the court made in support of the motion for severance. We think that's a wrong determination for this reason. The theory of causation on the 5 babies, I said the 5 babies and the Kemp baby. The theory of causation on the 5 babies is that they ingested a toxin, hydrazine, the rocket fuel. As a result of ingesting that toxin, they got liver damage. And the liver damage is because they drank the real water, had the rocket fuel in, they had direct exposure, their liver came in contact with the rocket fuel. And as a result of that, they had an injury, acute liver failure. Kemp case, let's compare it to the Kemp case. Exact same toxin, rocket fuel. Exact same injury, acute liver failure. Indisputed. On top of that, we cited the Andrade paper, which is the October 2023 consensus of experts. Histologically, when you look at the path slides, you cannot tell the difference on the path slides between the injuries of these plaintiffs. So you have an indistinguishable injury, but you have a slightly different mechanism of action. So what this really boils down to is a different mechanism of action. So our argument is that the rocket fuel triggered the AIH. In support of that, we have a lot of science that's really not in dispute in this particular motion, but that is the mechanism of action there. So here we have a slightly different mechanism of action. Now, let's take a look at their defenses, their alternative causes. They have the exact same alternative cause defense for the 5 babies in Kemp, which is that there's some phantom virus that there's no objective evidence for, but it must have happened. All 5 of the babies, that's the defense. Dr. Tanner puts forth the phantom virus theory. And that's the same defense Costco's putting forward for Kemp. So here we have the exact same toxin, the exact same injury, the exact same defense. And what they're saying is because there's a slight difference in the mechanism of action that they will be somehow prejudiced because the jury will be confused. This is the only causation issue that they're arguing about as some kind of confusion. I don't see the confusion, Your Honor. I think this is pretty simple. When you have rocket fuel, and it's either a trigger or it's not. The literature says hydrazine is a trigger for autoimmune disease. There's a published paper on that. The literature says hydralazine, which its primary metabolite is hydrazine, triggers autoimmune disease. What happened here is they hired an expert who said, oh, there's no such thing as a trigger for AIH. So that's what their hepatologist told him. That's what his report said. And so they were astounded when we came in with this trigger theory. All right. When I took that guy's deposition, I showed him all these papers by Dr. Andrade and everyone else, and he backed off, had to back off because he's not an AIH expert. He backed off and he admitted, this is Dr. Brown, he admitted in his deposition that hydralazine is a trigger. He wouldn't go and say hydrazine's a trigger, but he admitted hydralazine's a trigger. So we have a mechanism of action, the only issue remaining, where their expert has conceded that hydralazine is a trigger. And the only alternative causation they have is this phantom virus thing, which is the same thing for the other 5 babies. So given the fact that we have such overwhelming, and I think it is overwhelming, common issues of fact and law on all the other points, the same real water employees, the same experts, to suggest that this minor difference in a mechanism of action merits us trying pretty much the exact same case twice, 2 6-week trials costing about $1 million each. I just don't see that is a good use of either the court's time or the party's time. And, so really what they're saying is the jury's too stupid to understand that we have a different cause of action, or a different mechanism of action, which I think can be made crystal clear or they're saying real water stipulation of liability on the other cause of action implicates them on this. I think that could be cleared up with if it had to be cleared up. I would think counsel could point that out in argument. But if it had to be clear up, you can give a limiting instruction saying real water's agreement that these 5 babies are liable doesn't mean that they're agreeing the other 5 Kaveh's liable, and they're not. They're disputing that. And you can say that shouldn't cast any inference. But the alternative here is I've got to go back to a little girl and her family that have been the lead plaintiff on this case for 2 years and tell them that for some reason, the court has decided their baby's different than everybody else, and we've got to try their case at who knows when, And I just don't think that's fair, Your Honor. And for that reason, we think the Kaveh case should not be scissored. I mean, I've never seen a lead plaintiff scissored out of a case like this before. We don't think a lead plaintiff should be scissored out of the case. And we think she should have her day in court on May 28th, everybody else. Thank you.
Thank you.
Your Honor, just a housekeeping matter. My co-counsel is on Zoom and can't get in. Her name is Suzanne Richmond. I don't know if they need the court's permission to enter or not.
Okay.
Thank you.
Morning, Your Honor, Kevin Rising for Costco. Let's remember why we're here today. It's a motion for reconsideration. There has to be new facts, new law that they couldn't have been raised at the time of the original hearing. What you just heard from Mr. Kemp was a regurgitation of all the arguments that he made at the original hearing that you already looked at, decided on, and decided to grant the motion for a separate trial. Now I can go back through those and refute those, but since we have a time limit, if you permit, I'm asking you if you'd like me to do that.
It's up to you. You're more than welcome to, or however you feel comfortable.
Well, first of all, to let you know if the motion for reconsideration is meritorious, let's just look at a couple of things. First of all, a very good indicator that it wasn't meritorious is Mr. Kemp told you he's going to bring it at the end of the hearing where you granted the motion in the first place. How would he know that there's new facts, new law, or different arguments to be made at the end of the hearing where you granted the motion in the first place? Second, if you look at their motion, and we lay this out in detail in our opposition to their motion, there's no new law. There's no law at all. They don't even reference the standard for a motion for reconsideration. Their entire motion is a rant of different arguments untethered to anything that would allow reconsideration of the original motion. Again, you look through the entire motion, there's not a single case citation, there's no law whatsoever. The 3 new things that they have included, Mr. Kemp did not talk about it. We address it in our motion. They could have provided those in discovery in this case. They failed to disclose any of that in discovery. They have a brand new expert opinion that they failed to disclose. As a matter of law, the court can't consider that. As a matter of law, they shouldn't be permitted to reference that at trial or in opposition to any motion. You're going to hear that come up again later. And just so we know, I'm not going to go into this because we have limited time, but I think we're going to see this throughout the day. And I think it's going to be very difficult given that we have time limits. What Mr. Kemp does is he sets up a straw man. He says their only argument is that there's a different mechanism of action. As you'll recall, Your Honor, she has autoimmune hepatitis. She was going to get autoimmune hepatitis. She had autoimmune hepatitis no matter what happened. Her treating physicians and our expert agree that if there was any trigger, and that's a big question, if there was any trigger at all, because the majority of time there is no trigger for autoimmune hepatitis. You're born with it. It's hereditary. It's not the same. One of the plaintiffs in the case that was originally consolidated is not like the others, and Layla Kava is that. Can she get a trial date? We're willing to try her case at the earliest possible date that Your Honor can set it. If we set that today, we're happy to set that. We were happy to go on May 28th. They clearly don't want to do that. Last point is, in Your Honor, and this is in your order, judicial economy and convenience further favor granting a separate trial for Ms. Kava, as there is a significant risk that if Ms. Kava's trial is not separated, the parties will experience undue prejudice and an appeal will follow, resulting in the court potentially needing to retry all 13 plaintiffs' cases. Further, there is a significant risk that without a separate trial for Ms. Cava, the jury will be confused on the issues that make Ms. Cava different from the other plaintiffs. That's in your order. I question why Mr. Kemp would want you, on behalf of his other 12 clients, to reconsider that order and put them at risk for an appeal. This motion, your Honor's original inclination and original order in this case should be upheld. They've not remotely met the standard to reconsider the original order, and we ask that you deny the motion, Your Honor.
Thank you. Anyone else on the defense side? Well, okay, yeah, go ahead.
Your Honor, counsel said there's no new facts. I didn't want to get into it because but I will. So they heard you decline. When you came out last time on this motion, you told them that your initial position was you were going to decline it and join with Judge Alpha. So to turn you around, they said for the very first time, they said, Judge, out of 100 different plaintiffs, there's one AIH case and it's Leila Cave, and she is the unicorn. So that's what they told you at the hearing. That wasn't in their motion. That wasn't in their reply. In those two documents, they limited themselves by saying that this is the only AIH case out of the 10. Okay. But at the hearing, when they saw that they had already lost, or at least your inclination was against them, they came out with this new fact. Okay, Judge, you got to cut this case away because this is the only AIH case. Well, it's not the only AIH case. Come to find out that on that exact same day that we were having the hearing, they were mediating another AIH case that's represented by the Eglin firm, the Lisa King case. Okay. And in addition, there is yet another AIH case, the Boardinator case.
So when you say they, be more specific,
Okay.
Hold on. So
You
they
have
included
they
Costco?
being Real Water, Hanna, and Milwaukee, all of who joined in this motion. They went to the mediation of the Lisa King case.
Mhm.
Okay, so those three defendants, you know, this is what happens when you make a representation without doing your homework. But they had to know that there was another AIH case because they were attending a mediation that exact same day. And again, that's not my case. That's Mr. Eglet's case. Okay, so they bring this up. They argue that Leila Cave is the big unicorn. You've got to cut her loose, Judge, because she's only the one out of 100 that's an AIH case. So you can't try her with other cases. You know, and the reason that is so important, I think, is because all three of these women, Lisa King, Leila Cave, and Bourdonnais, drank from retail bottles that were made in the first quarter of January 2018. That's January, February, and March of 2018. Cave's AIH didn't get triggered because she didn't start drinking the bottles until August when she was going to school. She drank a liter a day. Before that, she was just drinking a cup. But all three of them, three women, got AIH at the exact same time. And this fact is first of all, is common exposure evidence under Wilson versus Circus that I think ends any kind of causation debate. But second of all, it disproves this virus theory because, you know, they say, oh, Leila went to school for the first time she's 6. Well, King was 28, an MMA fighter. Bourdonnais was 40. They got all AIH from drinking the exact same substance Leila drank. But Your Honor, bringing it back to where we started, this is why they told you at that hearing that this is the only one. Okay. And now Costco says, well, Judge, we didn't know that. And as we point out in our motion in paragraph, I can't remember if it's 62 or 68, we expressly alleged Lisa King 2018. Okay. We allege that she's a common exposure case in the complaint. Okay, so for them to say, oh, we didn't know about Lisa King, you know, but certainly the other three did, Your Honor. The other three that all joined in this severance, all presented arguments in support of the same severance motion. And that's why I think You know, that is the new fact, Your Honor. The new fact is that that representation they made was not accurate. They represented to the court that this is the only one AIH case, and that is not accurate. They concede now it's not accurate. You know, they have all this running and hiding that, oh, well, you know, we didn't see the records in Lisa King. Well, Real Water and Hanna and Milwaukee did. Oh, we didn't see the records in Bourdonnais. Well, Real Walker, Hanna and Milwaukee did. They didn't stand up and say anything. So, Your Honor, that is the key factual difference. And that's why, and again, they made that representation because they saw they were losing already with the court. And that's what turned the court around, in my judgment. And so for those reasons, we think the motion should be granted.
Thank you very much. This court sticks with its initial inclination, denies the plaintiff's motion to rehear the severance, although I am certainly rehearing it today. I am considering the substance, whether there's new facts or law cited. I am considering the substance and not simply saying, hey, procedurally it's improper. Cavey is unlike the other plaintiffs in this case, which is what I said prior. The AIH that she had different, the time frame of the consumption of the real water different substantially. I invited responses from plaintiff at that hearing to say, hey, they're giving me they on the other side, and even the statement about this being the unicorn or unique plaintiff was qualified. If you read that transcript, and I even invited response from plaintiff more than one time. So it's denied for those reasons, plus the reasons I already talked about in the original order. Next. And so defense, you'll prepare that or submit it to plaintiffs for review and approval. So on the non-MILs.
Sorry, Your Honor, I thought your process was the moving party.
Non-MILs, the prevailing party.
Oh, okay, got it. Thank you. Your Honor.
I didn't, that's my fault. I didn't.
That's okay. I just wanted to make sure.
Yeah.
Thank you.
Next up, I have a plaintiff's motion to strike, answer on order shortening time.
Judge Ron, we'd asked that that one be put over. Mr. Parker and I both made that request.
Okay.
We both have daughters graduating from college, and we're going to try and reschedule that. We thank the court and sorry for any inconvenience.
Okay. Let's see.
Your Honor, there is a companion motion on that. Cavey issued to set the trial date.
Plaintiff's motion to set the trial. That's next. Hold on one second. Let me.
Your Honor, while we're on the topic of the motions to strike answers, the plaintiffs have also filed a similar motion as to Milwaukee. It was filed, I don't know the exact date, but we still haven't filed our opposition to it. So we are requesting that the court hear that motion perhaps next week, but not today. And I did speak with Mr. Parker about this, and he doesn't have any objection to that.
That correct?
That's correct, Your Honor. I spoke with both Mr. Odou and Ms. Davis, as well as Mr. Kilroy, and I'm not objecting to it being.
Okay. Just remind me, if I bring it up, remind me that we already did that, or we need to do that, I guess. Thank you. So next up, motion to set the Cavey plaintiff's matter on next trial stack, preserve the current briefing schedule, inclined to grant this one, but welcome.
Yeah, Judge, on the, there's two parts to this motion. One, set it on the next trial stack. And then two, to continue forward with arguments on their motions in the next 3 days. On the first point, I looked at the trial stack again. There's 14 cases on that trial stack. The chances that we're going to squeeze a 5-week trial into that trial stack, I think, are slim and none. So what that tells me is that this case, even if you put it on the next trial stack,
Hold on, sorry. Give me the trial. Sorry, go ahead.
We're going to roll over to the trial stack after that, and the trial stack after that. More likely, this case is going to be set down for trial in October or November, which, you know, I'm fine with. The court's got to find time to do it. But that leads to the second issue, which is, basically giving advisory opinions on the summary judgments and the motions to eliminate. If this case isn't going to be heard for 2, 4, 6, maybe even 8 months, I don't think it's prudent for us to go forward on these motions at this time. And the reason I think that is this: there's another Costco case in front of Judge Williams to sit down for trial October 7th. That case is resulting in more and more discovery implicating Costco. So if the court were to hear a motion now, there is a high likelihood that we're going to have a rehearing because there's more discovery coming forward. That's problem number one. Problem number two, in the next 2, 4, 6, 8 months, whatever it is, there's potentially going to be Nevada Supreme Court cases coming down that may implicate the court's decision. So for that reason, I
Would
don't
that
think we-
be from one of the other trials?
No, just in general, Your Honor. I'm thinking, it seems like a kind of like Haley's Comet. Every 8 years they come out and they have an alternative causation ruling, like the Williams case and more Cicada. Every 8 years it comes around, and so we're kind of right now where Haley's Comet should hit us again. So I'm just thinking there might be something come out from the Supreme Court. But the more important point, the third one, is we got a lot to do, and so I don't see why we would be spending time on Costco specific motion. I mean, if it's something someone joins in that has to be decided before the trial, I'm fine with it. But a Costco specific issue, like, their causation issue, their punitive damages issue, my motion to limit Dr. Brown to what he said instead of what they want him to say, I don't know that we need to hear all that right now. So with regards to the second part of my motion, I'm withdrawing that. I just think from a case management point of view, especially, that's stupid to do. And so, if Your Honor wants to put it on the next trial stack, July 29th, that's great. If you want to put it on the one after that, because I don't think July 29th is realistic, I'm fine with that too, Your Honor.
Just so you know, my next one would be October 7, which it sounds like you all will be busy at that time. After that, I've got January 6, 25, March 17, 25. January's probably not good given how many I put on there, but maybe March. But think about that for now, and let's hear from me.
Yeah, I don't know. We need to decide that, Your Honor. I just think, this is a big production. If we're really not going to go on July 29th, I don't want to have experts canceling vacations, and I just don't see how we're going to go. Me looking at the trial stack.
Thank you very much.
Your Honor, when we're arguing for the motion for reconsideration, that's, we got to get Ms. Cava out as soon as possible. Let's keep her with this group. And now we want to kick the trial.
Well, I mean, I do understand, like, I just totally ruled against them on a point, so they have to, pivot and say, hey, here's the reality we're dealing with now.
I understand, but we're prepared, and we've drafted and filed.
And I've read,
my team has worked night and day, as everybody's team does, for the past 2 weeks, because they insisted on going forward on this motion schedule. What's become readily apparent that they're trying to do, and that's why he just brought up the other judge in the other case, is they're trying to now shop this around. What they want to do is they want to move this and consolidate it with another set of cases somewhere else. That's why they keep calling it a motion to sever. This case is still before Your Honor. It hasn't been severed out. It was going to have a separate trial. So we would ask that you actually set a separate trial if it's going to be in January of next year or March of next year now, because what we're going to have to deal with is sort of shenanigans and maneuverings to call it a motion for severance, to say it's a different case, to try to get it in front of a different judge, packaged with different other plaintiffs. And as you indicated, the Cava case should be tried separately. And it's your case right now, Your Honor. You have it. And we would like to keep it here.
thank you.
As to arguing the motions, we would prefer to argue the motions now because we're prepared to do so. I haven't given thought to which one might be only Costco. It's just that's not how we were looking at it. We were just preparing to argue. So I'm a little Yeah, I gotta dance a little bit on that. I'm not really sure
Okay.
which motions should be heard and should not be heard. We probably need to meet and confer on that issue.
Okay, thank you.
Thank you.
Your Honor, Joel Odou for the rural water defendants. We don't have a dog in this fight, so to speak, but I do have a trial set on July 29th before Judge Williams that will last about a week. And it is a 5-year case, so I just wanted to bring that to the court's attention. Whenever this one gets set, as long as it's not the same setting as another rural water trial, we're fine.
Anything from the plaintiffs?
Yeah, Judge, I mean, you know, they work night and day, they want to try the case, and the last motion, they don't want to try this case. So you can't have it both ways, all right? Either, let's go try the case now. If they want to try the case, come, let's try it May 28th, all right? I'm ready. You know, we can do it that way if they want to stick with their severance, which is what they want, because, you know, like I said last time, no retailer has ever tried one of these cases. They seem to disappear at the last moment. And I project, and we'll find out in a year from now if I'm right, that no retailer will ever try one of these cases, but we'll find out. Okay, so I just want a realistic trial date. I don't want to be calling experts up and.
Yeah, no, I agree with that. So in terms of the motions, we'll probably have to handle them kind of as we get to them today, tomorrow, Thursday. Yeah, some of them probably does make a lot of sense not to hear now. Some maybe, so we'll have to do that motion by motion basis, probably. Meet and confer tonight, you know, that would make a lot of sense. And if you can agree, great. If not, I'll just have to decide on any particular motion. Terms of the separate trial, so separate trial. So the Cavay case, still my case. I'm going to give you right now a potential new trial date. I am happy to reschedule to accommodate, you know, whatever you'll be in front of me, you know, many weeks coming up here shortly, and we will see a lot of each other to discuss things like that. So October, if you're already in front of Judge Williams, does not.
With the Costco case too, Your Honor.
Yeah, that's what, so I mean, that doesn't make any sense. January 6th, I just know from my, like, I have 1 billion trials on that stack. So I'm gonna put you, at least for now, March 17, 25. We'll give you an order that has all your new deadlines in there. One of those will be a pre-trial motion deadline, which may make sense to move some or all of these vis-a-vis Costco. So I guess motion to set the Cavay plaintiff's matter on the next trial stack, preserve current briefing schedule, so the second part withdrawn, but we'll have to handle those on motion by motion basis. To move the next stack, plaintiff acknowledged the next stack doesn't make a lot of sense, and neither does the one after that. For plaintiff, the January one doesn't make sense on my end, so March 17, 25. So I guess grant part as stated. And plaintiff side, you'll prepare that, submit.
Yeah, Judge, I just want one comment. This preemptive strike here that I can't move another AIH case into this case if I deem it appropriate. I don't see there's any grounds that I can't file a motion to consolidate. You know, if I.
So you mean, let me see if.
Maybe board.
No, I want to make sure I understand what you're saying. I think I do, but so you're saying potentially you would file a motion to consolidate another AIH case into the Cavay case.
I could do that, Your Honor.
I'm not
or I
saying you
could.
can't.
Yeah, well, I don't think any decision.
And
can
you've
be
heard
made.
my reasons for
Right.
why I separate the trials.
Right, so, but Your Honor, I don't think, you know, because and the reason I'm so cautious about this is the last severance, we had negotiated a pretty thorough order with Costco. And that might have eliminated the need to come back here today. And at the last minute, Hanna or Milwaukee, I can't remember which, jumped in and said, oh, plaintiffs got to waive their ability to file any future motion to consolidate or sever or anything, and, or, you know, and I said, wait a minute, I'm not going to agree to that as a condition. And that's why the order fell apart. And that's why we submitted dueling orders. So then counsel stands up today, Costco counsel, and says, oh, well, judge, you know, this is the way it's going to be forever. And there's no consolidation.
Well, I don't think they said that. That might be you putting that in, but I'm certainly not saying that.
Thank you, Ron.
Your Honor, can I just ask for one point of clarification?
Sure. Well, you can try at least.
You mentioned that the order will refer to discovery closed in the Cave matter, at least on April 1st. So I'm wondering, is your Honor's order that it remain, that it remain closed?
So I am not saying anything right now about discovery. So it's not in front of me right now, is how I put it. Next up, I have maybe this one that we continue, Costco's motion to sequence trial, but I do have a joinder to that. Although that joinder might be by a party that's not a party anymore. Does Costco want this one heard right now?
No, Your Honor, I think we can withdraw that
Okay.
motion.
So vacated and welcome to refile if you'd like it. Okay. Got next, Hanna et al.'s motion for spoliation sanctions against plaintiffs on OST. Is that one that we're moving, or is this one going forward?
So Your Honor, just a point of clarification. I think you got a note, perhaps last Friday, stating that Hanna and the plaintiffs have resolved, these cases. That doesn't change, unfortunately, for you, a lot of the work, because most of the motions that were filed by Hanna were joined by at least Milwaukee. And Milwaukee is still a party and will be included.
Oh, so when you said Hanna, you meant Hanna is very specific.
Correct.
Okay.
And the instruments, not
Gotcha,
Milwaukee.
gotcha. Okay.
And the, so there's only one motion in limine, I think it's number 8, Hanna's motion only number 8, which is Hanna specific, which I believe to be withdrawn. But
Okay.
otherwise, I believe that the rest of them are joined and will still be an issue argued by Milwaukee's counsel.
Oh, okay.
You know, that also means that when we have the motion to strike Hanna and Milwaukee's answer, it just would apply to Milwaukee.
Gotcha. We still, so like this one's Hanna and Milwaukee, right?
Correct.
Okay, so now we're gonna treat it as Milwaukee.
Your Honor, I would just add one more thing to that. In reviewing these motions for today, it appears that Hanna motion for summary judgment number 3 on punitive damages is also moved by the settlement with Hanna. Milwaukee filed a non-substantive joinder to that, but the request is limited to the punitive damages claim against Hanna and is specific to Hanna. So I don't know what the intention there is, but it appears to move to
Man, I don't know. So let's try to do, you know, there's an awful lot here. Let's stick with one at a time, because otherwise we'll be bouncing around.
I appreciate that. I just wanted to make sure that there's no suggestion that we're waiving our position that one is also
Just
moved.
remind me when and if we get to that one. So the spoliation sanctions now propounded by Milwaukee. Is this one that you all agreed to move like the other one, or no? Okay, okay, so I'll tell you what my initial inclination is then. So I reviewed, you know, this whole binder, inclined to deny for essentially all the reasons set forth in the opposition. I would point out that the reply in this case or in this motion does raise all sort of quote unquote new details. And I say quote unquote for a reason that weren't really in the motion. The issues to me really go to weight and or admissibility and not rise anywhere close to the level of sanctions. So that's what I'm inclined to do for those reasons, but welcome argument.
I mean, on just one point of maybe housekeeping, I don't know if I should call it that way. But I was just informed, and I appreciate Mr. Evans telling me this, but Mr. Fears was Hannah's counsel. When did he become Milwaukee's counsel?
Don't ask me,
I'm just trying to figure it out, John.
I'm just here to rule on things. So I don't care who argues
Your Honor, I will be making an appearance today.
for,
Milwaukee, just in this case.
for Milwaukee.
Yes. Just for
Okay.
today, just for this case.
I mean, and whether that has anything, any effect, I don't know, but, okay.
It's something we want to talk, if we want to push this.
I want to go
back.
forward right now. I told you what my initial inclination is and your time's a ticket.
So, Your Honor, I understand. And so if I get your position is you're denying it based on the opposition and the information that was put in the reply is new. Are you going to deny it without prejudice that, because as you are the lowest case and this is coordinated for discovery. And these issues that were raised in the reply, I think are very key to the spoliation that will affect a lot of the cases. Because while Hanna has resolved all its cases with Mr. Kemp, there are some cases that are still existing. That's why I'll be making the appearance in this case.
So to kind of answer your question best I can, which is not going to be a direct answer, but I don't see any, I mean, possibility, even the stuff in the reply that would rise to the level of spoliation. I mean, this is yeah, so
Well, then, Your Honor, let me just make my record.
okay.
So the issue that we have, at least that we just developed after we filed our motion, and it was outlined in the reply, is there are currently 6 meters that are in possession in the locked storage unit, or it's actually a safe in the storage facility, based on the production both by Plaintiffs. We call it the sink meter and the star meter, one because there's a marquee that has a star on it. The other one is because it's found by a sink and put in a white plastic bag. There's insufficient electrolyte. So what you have, if you look at the declaration, and I actually had a PowerPoint, we can do more high definition, but given the time and your ruling, we'll just focus on the declaration. If you look on page 1, what you have to look at, Your Honor, is when you put this device in, you have to complete a circuit. The circuit is 2 ways, because an ORP is really looking at millivolts. It's looking how electrons are moving through this system. The one is going to be the platinum tip. That is what is going to be measuring. And then you have if you look at the declaration.
So who's keep saying the declaration?
It's exhibit D.
Okay, I
and
was
I
gonna say, I
apologize.
assume
It's
I'm not
Jason-
looking at
it's
your.
Jason Babcock. I know there's a couple affidavits and declarations.
D has
You look at page 1, you see that picture. And on top, you have what is the plastic tube. You have what's called the reference electrode, the platinum lead wire, which connects to the platinum tip. So the platinum tip does go into the water substance, and you have to complete a circuit. It's like you have a battery. You have to put 2 wires or 2 connections to a battery to see how it's working, what its voltage is. So the platinum tip is one of those.
So hold up because I'm looking at.
Look at
I'm looking at this.
Unfortunately,
So I don't know
yes,
if I'm looking
exhibit
at
D,
the same thing.
I will. It looks like this, Your Honor, and I apologize.
Oh, man. Because I'm on
It's
D.
the first D of, if you go further back, Your Honor, I mean, go towards the front. There's another D.
I mean, yeah, I'm sorry, cause this is your time, but I mean, the only DI I'm seeing has a bunch of pictures in it. And then I get to plaintiffs.
Hey, Your Honor, do you mind if I approach?
Yeah, sure.
Okay, so here is the certification today.
Okay.
That'll probably help. And so you see that picture, you see the green tube.
Mhm.
You have the platinum tip, that is what actually goes into the liquid. And I have a more high definition version of that, Your Honor, if you wanted to, but I understand your ruling. Inside that glass tube, you have the platinum tip. It's connected to a wire that goes to the meter. The meter also has another wire to what's called the reference electrode. That reference electrode, when you go put in the liquid, there's electrolyte kind of substance that allows electrons to pass through to hit the reference electrode. And it's a potassium chloride substance. The issue, why this is important, is when we looked at the actual probes that were in the possession, there was a significant absence of that electrolyte that's in the probe. So you cannot have the junction between where the tip is. There's ability for electrons to go through that. And then right by the reference electrode, there's another junction that allows electrons. When you do not have that electrolyte, because it has been either evaporated, it's been gone, you do not have that connection. It'd be the equivalent of you taking a battery and you stick a wire to one side and then you just put the other one up in the air. Air is an insulator. The only way you get electrons through air is you have to have immense amount of energy. That's why we have lightning or an arc welder. So that is where we're saying that these probes have been destroyed, is because we cannot have that connection. We're then left in a situation because these were, and I don't fault plaintiffs going in for, and I know it's a practice in most of their cases, they're very proactive in getting preservation orders. And I think in looking at how Real Water ran their company, that seemed a very prudent thing to do. But when they took possession, and it was at that time only Real Water and plaintiffs, we do not have the picture to show if there is this lapse of electrolyte. So we're in this position that, one, there's an order that it's to preserve that doesn't allow testing. If we did test it, if it goes bad, then we have like, well, it's always been bad. We don't know because we don't have these pictures that show the absence of this electrolyte when it was taken into possession after this preservation mode, after the original preservation order was entered. And so we're caught in a catch-22 of, here are the two devices we know that were used. And now we can't say one way or the other whether they work correctly because we have this electrolyte that's missing that makes that connection. And so that's the reason why we are arguing our spoliation motion. Is initially we saw the crusting, we saw some evidence of the seeping of this substance that makes that connection between the reference electrode and the end of the probe. We've now gone and looked and we've taken the pictures, and I think the best picture, and I don't want to go through all the pictures, if you look at Exhibit K, if you look at the second picture on Exhibit K, and you see that probe and it has a ruler. Do you see that, Your Honor?
Mhm.
About at the 3 inches, and I'm going to say an eighth, if you move straight up, you
Mhm.
see the right edge of that bubble, that air bubble. That's probably the best picture. And this is, I think this is the sync meter, as we affectionately call it. We see that air bubble, which impacts the ability for this device to be tested. This is just not some exemplar. This is one that was actually taken from Real Water's facility. And so with that, Your Honor, we do believe there's spoliation. We've asked for the various remedies in our motion, and we ask that you would reconsider and grant our motion on that.
Thank you very much. Anything? You want to save your time?
Yes, Your Honor, I was just gonna say,
I mean, you're welcome to argue.
no, Your Honor, I think your inclination is exactly right. That everything he just said was brand new in the reply. None of it was in the motion. So we think your inclination was correct and we'll submit it on that.
Yeah, thank you. So sticking with my initial inclination, I mean, to me, this wasn't a close call. So denying now Milwaukee Instruments motion for spoliation sanctions against plaintiffs for all the reasons set forth in the opposition. The reply raises all sorts of quote unquote new evidence. It's not really new, but it should have been in the motion, was not, details, etc. The issues raised both in the motion and reply go to weight and admissibility of evidence and not rise to near any level of sanctions. Any order that's not a final judgment is always subject to potential revision, is how I would put that, but I don't see, having reviewed the motion and reply, I don't see it, but there you go. Plaintiffs' counsel prepare that order. I didn't read verbatim all the reasons in your opposition, but include those in there as well, submit it to the other side for review. Next, potentially at least, place motion for partial summary judgment against, I guess, against now Milwaukee, not Hanna. Here's my succinct kind of note, inclined to grant it, except as to Cavay, which certainly may be revisited now vis-a-vis Cavay in the future, but inclined to grant it. But welcome arguments.
Your Honor, can you?
Which number?
I'm sorry.
Sorry, this is there's no number on it, I don't think. Plaintiff's motion for partial summary judgment against defendants Hanna Instruments in Milwaukee.
I'm not gonna talk my way out of a win, Your Honor. I'm gonna sit down and reserve our time.
Based on doctrine of issue preclusion.
Yeah, it only pertains to Milwaukee. Your Honor is correct, and I appreciate the court's inclination. Thank you.
Certainly you'll have a rebuttal if you want. Okay.
Your Honor, again, excuse me, I'm Jim Kilroy for defendant Milwaukee. We are strenuously, obviously, going to ask you to reconsider this one. This is an offensive issue, preclusion issue. The case law that we cited advises the trial court to be really careful, particularly when we're dealing with a case involving mass torts, particularly when we're talking about a case where the prior judgment is currently on appeal. We agree in our opposition briefs, and recall that there were separate opposition briefs by Hanna and Milwaukee. Milwaukee joined Hanna's, that they come together, but they address slightly different issues. The Hanna response in particular focused on the dramatic differences in the plaintiffs, which is very common in mass tort cases. Differences in terms of their consumption, differences in terms of the temporal, the time that they consumed the water and so forth. The fact that this is a multi-plaintiff case doesn't relieve the plaintiffs of their individualized obligations to show causation. We have a completely separate motion for summary judgment. We don't think that any of the plaintiffs have established causation at all. And if so, there's yet another motion that's going to be heard today about several of the plaintiffs, and that goes to the conditions that were described in their medical records and so forth. But the point is, these are individualized inquiries, and the notion that we are subject to liability and causation determinations would kill our case. Another point we made in both the Hanna and Milwaukee responses is the fact that we do not have identical situations between the prior judgment and this one coming up. All issues were not actually and necessarily litigated in the underlying case. Literally, there was no determination of the merits of the claims against Hanna because there was an instruction not based on merits, but based on a discovery violation of Hanna's prior counsel that required the jury to find in favor of plaintiffs on liability and causation. That is not a merits determination by any stretch. We point out there's a separate Richt ruling where summary judgment was entered against Richt. In fairness, that was based on his failure to respond to admissions. Likewise, that wasn't a actually litigated issue. It's the same thing. This issue of liability has not been, or causation, actually necessarily litigated. Now we will hear Milwaukee's the only man standing of the meter defendants, but look at the sanction against Hanna and recall that the distributive chain starts with the manufacturer in Romania, goes to Hanna, the distributor, who in turn sells to Milwaukee, who in turn sells to Real Water. The instruction, the adverse instruction, was the death knell of Hanna's claim. It instructed the jury to assume liability and causation for Hanna as a legal and practical matter. That didn't just taint Milwaukee, it disposed of Milwaukee. The jury could have done nothing other than the exact same thing that they were instructed to do with the defendant one level up on the distribution chain. So at a minimum, Milwaukee is tainted by the association with a defendant, Hanna, who was assumed to be liable by the jury. I would go beyond tainted. I think that death knell ruling, that terminating sanction, also terminated the liability and causation determination against Milwaukee. We don't disagree on the analysis. We both focus on the 5-star case. We truly believe that the issues in these cases are not identical because you have to do an individualized causation determination. We don't believe that the issues were actually litigated in the underlying case. The result of the underlying case was a damages ruling that the jury was instructed to make based on a discovery violation. If we're stuck without the ability to defend causation and damages, like I said, that's the death knell for our case. Finally, yes, the fact that the Gallagher case is now on appeal doesn't legally change the analysis.
So it's a factor, right? I think.
Excuse me?
It's a factor though.
It's a factor. It's absolutely a factor. And the case law we cite, and I think it was in Hanna's brief in the reply, specifically instructs courts when we're dealing particularly with offensive issue preclusion, which is what we're talking about here. Offensive meaning this is being used to completely kill our case. When that underlying case is on appeal, we should tread very carefully with eyes wide open that the very possibility of a reversal, if this court grants the motion for summary judgment on issue preclusion, and there's a reversal of Gallagher, by definition, this one's going to be reversed without us even having the opportunity to defend this case. There are other issues once we get past the 5-star analysis that I want to address, and this is the general equitable consideration that the court is required to do under the Park Lane Hosiery U.S. Supreme Court case. And again, I'm stressing that because it's so important, we're talking about a mass tort case with individual plaintiffs who by definition have different consumptions of different water at different times. The notion that they can be relieved of their burden of proof on the most important elements of their claims, I think is incorrect, but it's certainly unfair. We address the factors the Supreme Court reviews in determining whether to exercise the frankly unusual discretion to apply offensive preclusive effect. Would doing so incentivize plaintiffs to wait and see? Well, we have a disagreement about that in the briefs, and I won't repeat what's in the briefs. Are there different procedural protections that may change the result? This is why that sanction is so important. Absolutely. Absolutely, there are different procedural protections. The procedural protection in this case is there's not a life-ending sanction against the meter defendants as there was in Gallagher. Fundamentally different, fundamentally unfair to hold us to a discovery violation where there's no evidence that there was any such discovery violation in this case.
Let me add, trying to think of how to articulate this, as you just mentioned, for example, the meter defendants, plural. Plaintiff points out in particular in the reply, hey, at least according to them being Hanna and Milwaukee, at least according to Hanna and Milwaukee are separate entities. The sanction only applied against Hanna, not as to Milwaukee. Now you're Milwaukee, I think, arguing up here. So are we talking about a sanction that applied to both entities or only one, or are you talking about separate entities or the meter defendants?
I'll talk about what the jury instructions say and how it applies in the real world. What the jury instruction says is Hanna committed, it was Hanna's counsel who was penalized by Judge Williams in the Gallagher.
Prior counsel, to be clear.
In the prior case, the literal instruction is directed at Hanna, but if you look at jury instruction 21 and then 37, both referred to in the Hanna briefs, the instruction number 1 describes this vertical privity, the distribution chain. And it also instructs that Hanna, which is above Milwaukee in that distribution chain, is liable, not just in general, but for the claims asserted for a claim of an unduly dangerous, unreasonably dangerous product and failure to warn. It's the same product, the MW500. So we can parse the language in the instruction, but how could a jury with that admonition, that instruction, have different conclusions for the two parties in the same distribution chain in light of the other instruction that says that you're not relieved when you're in the distribution chain? It's the same product. It's jury, all jury knows is MW500 equals unreasonably dangerous failure to warn. There's no other way around it. In fact, had the jury come back differently, plaintiffs would have had a argument that it makes no sense for them to come back differently. Again, if that's even a close call, and I don't think it is, enormous discretion combined with caution when we're dealing with offensive issue preclusion. Your Honor, this one obviously is very important to us, and we do ask you to reconsider.
Thank you.
Good afternoon, Your Honor. Do you have any questions first before I start?
Well, so maybe not a question per se, but I think it would behoove you to address, this, is there a difference between the entities? Are we talking about Milwaukee versus Hanna, or are they combined? And if they're separate, they still argue that even though they are separate, the jury essentially had no choice. So that's just a soliloquy of saying, yeah, go ahead. Sorry.
No, I appreciate it, Johnny. Your soliloquy at least provided me a roadmap of what I should address, so I appreciate it, Your Honor. I will first say that Mr. Kilroy was not a part of that last trial, or 2 trials ago. And so I'm assuming he's taking from perhaps his review of the transcripts, his understanding of what happened. Fortunately or unfortunately, I was actually there. And I will say vehemently that Mr. Robbins argued to the jury, I thought very effectively, the differences between Hanna and Milwaukee. And in fact, Mr. Robbins kept pointing out to this jury that while Hanna may have created the document, the meter, and some other company may have created it, an affiliate in Romania, Milwaukee was responsible only for the tip card. And if we failed to warn, that's what Milwaukee may have failed to have done. A very, I think, a stark difference between making and warning about it. They made, I would say, days, if not hours, I would say days of time committed to showing the differences between Hanna and Milwaukee. In fact, we tried to use an organizational chart of all 124 businesses affiliated with Hanna. They objected, and the judge wouldn't let us get it all in, just to maintain the separation of these companies. And so part of Mr. Kilroy's arguments were not a part of his opposition. I'm sure you noticed that, Your Honor.
I mean, that's okay.
And that's fine. I'm going to address them anyway, but they're not there. What I will say to you, Your Honor, is that our special verdict form, we thought did a disadvantage to the plaintiffs because the judge said and reinforced with the jury, our decision in terms of Hanna has nothing to do with Milwaukee. In fact, you have to specifically find that Milwaukee is liable. And I didn't like this very long special verdict form. And if you go to page 7 of our initial brief, Your Honor, it says right here, did Milwaukee fail? Yeah, go to page 7, Your Honor, if you could.
It's gonna take a second. Or several. Okay.
And if you look at page 7 of our moving papers, Your Honor, it says here, did Milwaukee, this is paragraph 2, starting in line 7, did Milwaukee fail to provide an adequate warning that would have been acted upon? This has nothing to do with a combination of Milwaukee and Hanna. These are specific to Milwaukee and Milwaukee's failures, Your Honor. And then it went through and says, the answer to question 2 is yes, was this a substantial factor in causing the injury to each of the plaintiffs? And it goes down. Your Honor, we went through, if you go to the next page, paragraph 4 of the special verdict form, this is that line 12, did Milwaukee breach the implied warranty of fitness for a particular purpose, i.e. was the MW500 ORP meter unfit for measuring negative ORP when making alkaline water? We had the benefit of Milwaukee employees at this trial. This was completely a Milwaukee issue. The verdict form confirms that. And Milwaukee, unlike today, where we have a Hanna attorney appearing on behalf of Milwaukee, we actually had a full staff of Milwaukee attorneys arguing on behalf of Milwaukee and separating themselves from Hanna. Your Honor, what I thought was curious, if not predictable, is how far Mr. Kilroy stayed away from really the 5-star case, the LaForge case of 2000, the Nevada 2000 case, and the Department of Communications and Rehab, the California case that we cite, both laying out the 4 factors for when issue preclusion should be used.
Thank you.
You're good, fine, Your Honor? Needing no more questions need to be answered? Thank you, Your Honor.
No, so, sometimes my memory does need to be jogged a little, given that I've reviewed, thousands upon thousands of pages. But,
One down.
right?
Oh, I'm sorry. Go right ahead. No, it was our motion, Your Honor. He
Yeah,
opposed.
that's what I'm.
That's what I'm wondering why he's getting back up.
Just ask me if I may reply. You're the judge.
No, you can ask and I'll say, thank you, but no, that's fine.
No.
Okay. So movement, opponent movement, especially now that we have, how many of our motions. But so yeah, sometimes my memory does need to be jogged as far as what I did read and this one, I'm sticking with my initial inclination. Granting it, as pointed out, the separateness of Milwaukee and Hanna during the Gallagher trial. We have the jury verdict, special verdict form that clearly applies, and now we're arguing about just as to Milwaukee. So the issue with the sanction of Hanna at this point is largely, if not entirely, irrelevant vis-a-vis Milwaukee. The motion granted for all the reasons. I mean, going through the legal argument in particular, I'm relying on what the jury already found. I think jury, they did what they did, and I have full confidence in them as a jury. Yeah, it's on appeal, but that is not, like I said in the separate trial motion, it's not it's not an end all be all, like judicial economy and the other issue. But issue preclusion applies. The failure to warn issues are identical to the issues decided by the jury. The parties had an opportunity, full, fair opportunity. Parties, again, now, especially being Milwaukee, verdict was on its merits, involved Milwaukee, against whom judgments asserted in this case. Failure to warn issue was actually necessarily litigated. Could go on and on and on. Also, though, going to the reply, some key points made in the reply. In particular on pages 9 and 10. 12 and on. I mean, 9 through the end of the reply, very succinct, directly on point. I mean, they're essentially reiterating a lot that was in the motion, but addressing in particular to the opposition. Yeah, this has already been done in front of a jury. Same parties, notice an opportunity to be heard, 5-star case. So prepare an even more detailed order, though, submitted to opposing counsel for review and approval.
We'll do, Your Honor.
Thank you.
Your Honor, would this be a good time for lunch?
Sure. Anybody object?
Judge, I have a number of motions that I think are moot that I can inform the court of the other parties before we go to lunch, perhaps.
Sure.
Can you write motion summary judgment number 2? When the Wren water was not met at the Henderson plant, that becomes moot because that's really a retail bottle issue, the purpose of that motion. So that's moot now that Costco is now the case. Obviously, motion for summary judgment number 4, Costco sold real water consumed by Kemp, that's moot. Plaintiff's motion for summary judgment number 6, taking negative the ORP readings, that's moot, given the court's ruling just now. And number 7, the Kemp plaintiff's strict liability claim an adulterated product against Costco and real water. Since Kemp is not in the case, that's moot too. So,
And I won't ask anybody on the other side to confirm that right now, but when we come back, I mean, I'm prepared for all of them. So if anybody thinks otherwise, we could talk about that. And you wrote them all. Okay. Anything else on the other side before we take a break?
Your Honor, given Mr.
Kemp.
I can't, I'm totally blanking today, Teddy, Mr. Parker.
Oh, okay.
Wearing two hats.
Teddy's fine.
Teddy's fine, wearing two hats, apparently. We did submit an order on OST for a good faith settlement. I have a hard copy if you would like that during month. It was condition of the settlement agreement to get this on as we submitted today. So, we did submit it through your, email inbox.
So we'll set it
I have
on
a hard
Thursday, hopefully. Okay,
That would be great, Sean. Thank you.
that way we have a 1 day notice for that.
I'm sorry, Your Honor, I didn't hear. what
Oh,
you
we'll
said.
set it for Thursday.
Thank you.
Anything else on that? Sam? Come back at, well, let's come back if we can. I'd say 1:15. I know that's not an hour, but.
Yes, Sean.
Oh.
Thank you.
Thank you.
Any disputes on withdrawal of those 4 that Mr. Kemp talked about?
No, Your Honor, Mr. Kemp and I discussed, and Costco is also willing to withdraw its motions for summary judgment 1 through 3
Okay,
without prejudice to
okay,
refile.
yeah, certainly. Thank you very much.
And we will take a look at the motions in limine and see which ones of those we can withdraw.
Okay,
Maybe all of them with a stipulation.
okay,
An agreement.
sounds good. So,
Your Honor, Don Davis for Milwaukee Instruments, as to plaintiff wanting to withdraw their partial summary judgment number 6, fine. Milwaukee still has its own motion for summary judgment as to standing that we maintain is not moot and still intend to argue.
okay, thank you. All right, I think next, would be plaintiff's motion for summary judgment number 3. That all plaintiff's medical expenses to treat liver injury are deemed reasonably necessary and customary based upon lack of defense expert testimony. Everybody okay going forward with that?
Your
Your Honor,
Oh,
go ahead, Eric.
We've actually reached an agreement on that one.
okay,
There's not really a dispute as to the past damages, so we're gonna put that into a stipulation and submit it to the court, so
okay,
no need to argue that one.
okay. That's easy. And while he's looking for that, we have approximately 20 minutes done on plaintiff's side and 27 minutes done on defendant's side. So we're moving along, so that's good. Do we have Milwaukee's motion for summary judgment on all claims? So I'll tell you what I'm inclined, are you gonna argue, right?
Yes.
Okay, just double checking. Tell you what I'm inclined to do. Trying to decipher my own notes a little bit. Okay, yeah, so I'm inclined to deny because genuine issues of material fact exist and largely to the extent in terms of this motion and largely to the extent that there are issues of fact. So I'm saying that, so here's kind of the caveat. So obviously I just granted a summary judgment on the issue in favor of plaintiff. My inclination to deny this one is just on this particular motion itself, and not on, every other motion for summary judgments, how I would characterize it, but here I think there are genuine issues of material fact. And so I'd be inclined to deny, but welcome arguments.
Thank you, Your Honor. As we understand the ruling prior to lunch on issue preclusion, the court has issued a ruling on issues, not claims. It was not a claim preclusion argument. And the issues the court has granted preclusive effect to our liability, Milwaukee's liability, and causation, literally meaning that our product approximately caused damages to the plaintiffs. We've already made our argument on that one. This one is different. No matter what, you need standing. No matter what, that is the first step of any lawsuit. It's an issue typically of subject matter jurisdiction, but in any case, it's how you get there. And we argue that the plaintiffs did not have standing.
So this might be a question maybe more for plaintiffs, but also for you, because I'll ask plaintiffs the same. So there seems to me to be a little bit of, I don't know if disconnect's the right word, but our plaintiffs really proceeding under, a UCC claim per se, or are they really proceeding under claims for strict products liability? The distinction between the two, I think both sides here may agree, may not agree, but it's a little muddy in terms of my trying to follow it.
Well, from my standpoint, and plaintiffs will speak for themselves, but
Yeah.
they're clearly pursuing both. There are three claims for relief: an implied warranty claim for failure for fitness of particular purpose, and there's two tort claims for strict liability, unreasonably dangerous product, and failure to warn. One is a statutory claim, obviously, as the name warranty would imply, fundamentally based on contract law. The other is a tort claim that's developed over Nevada law in all jurisdictions, specifically following the restatement second of torts 402A. That distinction is important, and I'm glad you asked the question because they're pursuing both. But the standing analysis is fundamentally the same in one sense, but different in another. The same because you get to the same result, which is why the plaintiffs pled this way. You have claims where the plaintiff does not have to show fault. So there is an effort apparently to avoid fault-based claims, a strategic effort, and I'm not blaming plaintiffs for following that path, but there is no negligence claim. Different because one, the statutory claim defines standing under the UCC, under the statute. The other doesn't. The other's a common law claim. So let me get to both. And it's really important to make that distinction when you review the cases, because the confusion, the muddiness, I would submit, comes in the plaintiff's opposition, where they make bold pronouncements such as there's no requirement of privity for strict product liability claims. To be clear, under the UCC claim, the implied warranty claim, our position number one is that standing is identified in the statute as any person who is in the family or household of the seller's buyer, or who is a guest in his or her home. And I should back up. That, of course, is the qualifier. In other words, the user of a product has standing, but so does a person in the family or household. That is called horizontal privity under Nevada law. There's a separate concept called vertical privity, and that privity concept evolved over UCC cases to establish that Nevada does not require vertical privity, which is privity basically in the distribution chain from manufacturer down. We have never suggested that Nevada law requires vertical privity. We have not only suggested, but maintained that Nevada law does require horizontal privity for implied warranty claims under the UCC. We've never said that Nevada law requires horizontal privity or vertical privity for the separate tort claim that I'll get to, but we do have to separate these claims entirely. So if you start with that proposition that you need horizontal privity to state a claim for implied warranty, there is no question or suggestion that the plaintiffs in this case are in a horizontal privity relationship with Real Water, which was the purchaser of the product at issue. And the product at issue, remember, it's not the water. From my standpoint, it's the MW 500. Nobody has said there is horizontal privity. Instead, we have arguments in the response that really do require a review of the cases, because bold pronouncements, for instance, that the ad art case says that horizontal privity is not required. That case doesn't even deal with the UCC implied warranty claim. Again, it's the tort claim. Every instance they have under Nevada law of pushing back on this notion that Nevada law does not require horizontal privity, every single one, and they're going to get a chance to correct me, is a 402A tort case, not an implied warranty case. Every single one. There is not a Nevada decision that says horizontal privity is not required for the UCC implied warranty claims. And we've cited the historical cases. I won't just repeat what they are, but they remain good Nevada law. The federal courts as early or as late as just last month adopt the same approach. There is an unbroken chain of case law that says what should be obvious, which is the statute. Standing comes from the statute in the first place. And the statute is neutral as to vertical privity. And the courts certainly, in light of that neutrality, have been able to and have made judicial decisions that reflect this current state of the law in Nevada, which is vertical privity is not required. No cases have done what plaintiffs are asking you to do, which is say horizontal privity is not required for a UCC implied warranty claim. None. As to the strict product liability claim, again, the analysis is different. It's not based on a statute. It's a tort claim that is expressly and historically applying restatement second of torts 402A, which in pertinent part says one who sells any product in a defective condition, unreasonably dangerous to the user or consumer or to his property, is subject to liability for physical harm caused to the ultimate user or consumer or to his property. So the definition is user or consumer. This is common law. This one has a little more, perhaps a little less strident application than the UCC statute, and is subject to some interpretation. Comment O of the restatement 402A sheds some light on that. It suggests that you may be able to go beyond the strict user or consumer of a unreasonably dangerous product, but you're cabined. And comment O is, and this is again where we may have been misunderstood. Comment O talks about bystanders and how there have been instances where bystanders do not have standing. We've been generous in our interpretation that Nevada law, which is not, Nevada Supreme Court has not yet ruled whether bystander has standing under 402A tort claims. We are assuming that indeed they might. And one of the reasons is a case that Mr. Kemp handled, and I may be mispronouncing it, but I think
the bus case.
Kayabani case.
Iabani.
Case. Interesting case. And the issue there, I think, distinguishes what we're talking about from what happened there. Even the outer limits of standing under the tort principle of 402A require you to be a bystander. We argue that these plaintiffs can't be bystanders because they were not injured by the product at issue here, the MW 500, and they weren't in proximity to that product when it was being used, which was in a real water facility where some employee of Real Water decided to dump concentrate into a vat of water. The distinguishing factor of Kilbani is the plaintiff there, as I understand, was a bicyclist who was biking near a bus that had a boxy design, which caused a sort of draft to pull the cyclist in. That is a bystander. That is our humble recognition that Nevada certainly could extend standing of 402A claims the way it occurred in Kemp. That's an individual who is reasonably expected to be within the use of the product bus and who was actually injured by the bus. That's a bystander. What we have here is completely different. And I'm not saying there's no claim for relief from the plaintiffs. I'm saying this is a typical negligence going back to the first year of law school kind of case where it's more attenuated than we permit when we impose strict liability on defendants. The policy reasons for cabining standing under both the implied warranty claim, which is statutory, or in the tort context, which is not, are really the same. We're giving plaintiffs a unusually strong liability opportunity to obtain damages without having to show fault. The trade-off for that is the individuals who are subject to that kind of liability have to be limited. And that's the policy behind the policy in favor of the plaintiffs is we're going to give you extraordinary liability opportunities without having to shoulder a burden of showing fault and concern about allocation of fault between parties and so forth. But the trade-off is not everyone injured by a product has standing under either the tort principles of 402A, but certainly not under the statutory requirement of the UCC, which is what the implied warranty claim is based on. From our standpoint, this is a dispositive issue. We don't even get to anything else because these folks did not assert causes of action that entitle them to relief.
Thank you very much.
First problem with their argument is they are trying to undercut the Gallagher judgment. And in the Gallagher case, this exact same argument was presented, the exact same argument, almost word for word, because we cribbed from the briefs and the oppositions and the replies in that case. So word for word, they made this argument in the exact same type of motion for summary judgment, argued that there's privity required for breach of implied warranty, arguing that the bystander, the failure to warn liability, you have to have some sort of temporal proximity or something, I think was their term there. But they argued in their motion for summary judgment, then they filed a Rule 50 motion, then they lost, and then they filed a judgment NOV motion. Now there's a judgment, and that's what the court has already ruled they're bound by under the 5-star rule. So you can't go back and argue, try to undercut the judgment, by calling it something different, which in this case is standing. So I don't even think procedurally that this motion should be allowed because it's encompassed by the previous decision. It's just an attempt to attack the previous ruling of the court. But assuming for the sake of argument, we're going to get into the merits of this on the breach of implied warranty claim. And again, the privity argument, these exact same cases were cited to Judge Williams on privity. They've conceded that you can't remember which one, I got vertical, I'm confused sometimes, but they conceded it and there's only one left. And so we
So
cite,
they say horizontal is required, I
Right.
think is their argument.
okay, so we cited Justice Beulah's opinion from about 2 years ago, where she was talking about privity, saying the doctrine of privity is gone. But that's pretty much what she said. So we are left with what would the Supreme Court do now as opposed to what they did 60 years ago in the Long case. This is the same issue that Judge Williams confronted, and he said, no, I don't think you need privity. So he let the breach of implied warranty claim go through, and the jury found in our favor. On the failure to warn claim, I mean, I think their argument, I'm surprised they're even making it. Kiabani, it's pronounced Kiabani. That was my case. That was the bicyclists up near Red Rock. And so they argued, oh, he wasn't sitting on the bus. So there's no failure to warn case there because he wasn't an occupant of the bus. And so the Supreme Court jumped over that and said, no, bystanders can bring failure to warn. So now they're arguing, well, you're not really a bystander because you weren't in the plant. You have to be in the real water plant. And as I argued in front of Judge Williams, I think the real test here is foreseeability. Is it foreseeable that the product could potentially implicate these type of people? And in that vein, I relied on the Price versus Blaine case. That's the mask case where someone was wearing a George Bush mask and he gets pushed from behind and the mask is not designed to be, it just tips right over. It doesn't have any stability. And so the argument there was, I can't foresee that a criminal was going to push someone from behind at a political protest because he's wearing a George Bush mask. And the court went through a real long foreseeability analysis. In this case, there's no argument about foreseeability because they represented that this meter was fit, the go-to, the proper meter to be used by people making alkaline water. They made that general representation to everybody, and we introduced a lot of interactions with customers to that exact point. With regards to Real Water sent them inquiries about this meter, and there was an exchange between them. So they may have not been to the Real Water plant, but they knew that they were selling this meter to someone that was making alkaline water. So they had objective knowledge of the use of the meter, and they had subjective in this case. There's no possible argument that they could not foresee that this meter was being used to make alkaline water. And so that really ends the analysis that strict liability doesn't extend to them. You know, I can see there may be some cases, let's say they were using the meter, I don't know, as maybe some kind of electrical conduit in, you know, in a spacecraft or something, or a plane. They had to do it on an emergency basis and it shorted out. You know, you can't foresee that your product's been used in that kind of a wacko far out scenario. But this is not a wacko far out scenario. This is one they expressly anticipate. So if we apply the foreseeability test, which is, I think, the test that should be applied on the strict liability end of it, clearly they can't meet their burden. And even if they had offered evidence that they couldn't foresee that this meter would be used for alkaline water, it's an issue of fact. I mean, this is not a summary judgment issue because as I've already alluded to, you've got all the emails about it being the fit and the go-to and the proper meter can make alkaline water. You got the product literature to that effect, and you got them actually talking to Real Water people about this exact, or emailing, I guess, maybe not. So for that reason, Your Honor, first of all, like I said, I don't think you can undercut the previous judgment and get out from the collateral estoppel effect by arguing, the judge made a bad decision on standing. You know, I can go to the next court up and say, there's no, you know, let's ignore that judgment because the judge should have dismissed the complaint. He should have granted the summary judgment. He should have done this. He should have done that. You take the judgment as you find it. So I don't even think procedurally we should be hearing this motion, but if we do hear the motion, like I've already said, there's issues of fact.
Before you sit down, so tell me about, is this really a claim? And maybe it's just my confusion, but is this a UCC claim or is it a strict product liability claim or some type of hybrid? Or
I think it's both, Your Honor, because we pled it as a breach of implied warranty claim. And the reason we did it is we thought, you know, you don't see that a lot because usually you have to have some sort of interaction between the product manufacturer and the customer, you know, because they have to know what the product's being used for. And in this age of mass market products, you usually don't see that. You know, people are buying stuff on Amazon. It's hard to say that there was an implied warranty of fitness for a particular purpose because usually the seller doesn't know what the purpose is. In this case, they knew what the purpose was and they promoted it for this purpose. So in this particular case, we pled them both, the breach of implied warranty and the failure to warn as alternate theories. And that's why when Mr. Parker showed you the verdict form, there were separate questions on the verdict form. Did, the breach of implied warranty cause Gallagher? Went down all the plaintiffs, all 7 of them, one at a time for each one of the theories. So this was kind of a belts and suspenders approach on our part because we didn't want to, the failure to warn case, they were trying to argue that, they should have known that the conditioning instructions were wrong and we told them this, and we really warned. So it was an alternative theory of liability because it didn't rely upon the warning. And so that's why we did it. So what I would submit is that, yes, this privity argument, they're making it right now on appeal. Okay. This is the foundation of their summary judgment motion that they argued repeatedly to Judge Williams, and it's gonna be the foundation of their appeal. So if the Nevada Supreme Court, and I told Judge Williams and I told counsel, quite frankly, why are you pushing this breach of implied warranty when you've already won the failure to warn? You're just trying to shoot two bullets in their heads. And I said, we need to extend the law, and this is the case to do it in. So with regards to breach of implied warranty, we're candidly, we're doing this to try to get this the 60-year-old long case into the dustbin where it belongs. But there are alternative theories. We don't need to win them both. And like I've already said, if worst case scenario for the plaintiffs, the Nevada Supreme Court says, oh, no, there is no breach of implied warranty. They're right. This long case requires privity. That is why we brought the collateral estoppel motion under both theories, the failure warrant. So that would stand. So the Supreme Court would have to reverse both of those in Gallagher to have an impact on the court's previous decision.
Thank you very much. Any rebuttal?
Just make an acknowledgement that this case is designed to change the law. That's all.
Oh, thank you. We're going to stick with my initial inclination, but add some reasoning to it. So court denies without prejudice, read the title. Milwaukee Instruments, motion for summary judgment on all claims for all of the following reasons, several of which are alternative, but one, genuine issues of material fact exist. Two, I don't believe under current Nevada law that horizontal privity is required. In current law being the in particular but not limited to the ad art case, the Chiabani case, this court's ruling earlier this morning, the Gallagher case, the Hunwartson case. I think I agree with plaintiffs in terms of foreseeability being the key versus any strict compliance, so to speak, of requiring vertical and or horizontal privity. And then whether plaintiffs in this particular case can be considered whether plaintiffs can be considered bystanders in this particular case. Again, I think the focus is would be on foreseeability under cases like ad art and Chiabani. For all those reasons, denied without prejudice. So Mr. Kemp, you'll prepare that order, submit it to Mr. Kilroy et al. for review. Yeah.